What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. I'm working on a few things this week that I think is going to be of very importance to everybody that is having issues with credit repair and also dealing with debt collectors. Now, I'm going to have I'm hiring a company to actually read out the Supreme Court decision back in 2017, where the opinion, decision on Henson versus Santander Consumer USA Inc. was decided, and in short, what it stated was that if a debt collector buys a debt, they assume the role of the original creditor, which is strange. It is, I don't know how that can happen if they're not the originator of the debt. And the reason why this happened was because the Supreme Court, and it was not a unanimous decision, they're basing this on the wording, which is they're saying that so let's back up. If the original creditor is not routinely going out there to collect debts, they do not consider them a debt collector. But that's kind of crazy, because if you have a debt with an original creditor, they're sending you out notices every month to collect on that debt. Now, but they're saying that if it's the original creditor, they are exempt from following the Fair Debt Collection Practices Act. That's what this whole case was about. And it went on and on about, using certain words, certain language, this and that. And it basically came down to this. City Financial Auto sold debt to Santander Consumer USA Inc., which I didn't even know that Santander actually bought debt and tried to collect on it. I thought that they just, made auto loans and went out there and collected on it. So when that happened, when City Financial Auto sold it to Santander and tried to come after an individual for the debt, the individual said that Santander must follow the Fair Debt Collection Practices Act. They, somewhere with the way that they were coming after them for the debt, probably with a debt validation or something, that they were not following the Fair Debt Collection Practices Act. And this ended up working its way all the way to the Supreme Court, and the Supreme Court decided that Santander did not have to follow the Fair Debt Collection Practices Act because they were not a debt collector, which with this opinion, a debt collector is someone who is hired by the original creditor to go after someone for debt. So in essence, what they've done is they've made it to where debt collectors can buy the debt and assume the role of the original creditor. Now, I know you might be thinking, well, if they're doing that, that's going to make it harder for you to be able to repair your credit, number one, and then also validate the debt with the debt collection company who purchased the debt. Not necessarily. Now, even though the Supreme Court said that there are loopholes for debt collectors when they buy debt and assume that position, but they wanted to leave it up to Congress to fix those loopholes and make updates to the Fair Debt Collection Practices Act. But let me tell you the loophole that I see the debt collection companies, quote unquote, portfolio buyers, this is a loophole that they're using. So let's just say portfolio recovery, which is one that I had reviewed with a previous client, where they had numerous marks on their credit from Portfolio Recovery Associates. Now, what most of the time, what we would do, or other credit repair companies, or what you would probably do, is you would request a validation from the credit reporting agencies to go to Portfolio Recovery. And if you're using the credit repair shop, you would also do that directly to Portfolio Recovery Associates. Now, according to this decision, Portfolio Recovery Associates would not be required to follow the Fair Debt Collection Practices Act because they purchased the debt And the way that it's stated in this decision, when you purchase the debt, you are the owner of the debt, and you could go and collect it. It's very confusing, but you can go and collect on that debt without following the Fair Debt Collection Practices Act by the letter of the law. This is just the way it's stated. And I know that might sound crazy, and I made a video about this in the past, and reading more into this 11-page decision. Justice Gorsuch wrote the decision, or the whatever they call it, for the prevailing side, and stated that the way that it is written by the word, like they're breaking it down by words, like owned. If you own the debt, they consider you the owner of the debt, and that you don't have to go follow the Fair Debt Collection Practices Act. Now, let's talk about the loopholes, the way that it's being utilized, that I'm seeing, like in practice. I'm seeing the portfolio companies utilizing this loophole in two ways to really put a lot of pressure on people, and to also not have to really go out there and be the debt collector. They can kind of bring people to them, people that are trying to resolve their debt. So portfolio company buys the debt. Portfolio company places the information as if they're the original creditor on the individual's credit report. Now, if you've watched my other videos, one of the things that I stated, that you can get a charge off removed off of your reports if the Supreme Court is saying that they are the originator or the new owner of the debt. That means that they've purchased that debt from the original creditor. It cannot be really considered a charge off anymore, in my opinion, because they've accepted payment. They're not hiring a company to come after you for it. They've accepted payment for it. So let's be very clear. So step one, portfolio company buys the debt. Portfolio company puts that information on your credit reports. Portfolio company utilizes the Supreme Court ruling to not have to follow the Fair Debt Collection Practices Act because they assume the original creditor position. Because that's their little loophole, your loophole is to challenge the original creditor and state you must either mark this paid or remove it because you've sold this debt to a debt collection company or portfolio company, and they are considered the owner of the debt, and now you've taken money for that debt. It is not considered a charge off. It is not considered you getting a third-party debt collector to collect on that debt. Now, what the portfolio companies are utilizing for their loophole on this is that they're placing that information on individuals' credit reports, and they're not actually going after people for the debt per se. So they're not sending out letters. They're just placing that information on there. Have you ever wondered why it could have portfolio recovery on all of your, like it'll say portfolio and the original creditor, portfolio and the original creditor. It'll be listed on your credit reports, but you've never received a letter from portfolio recovery. And the reason why is because they're utilizing this loophole with this decision. So what they're doing is they're harming you with your credit because they're putting those accounts on there as if they were open. And then what they're going to do is they're going to slide those over, assume, sell, whatever, to a third-party debt collection company to come after you as a debt collector. So what I'm thinking is happening, is when they use that wording of, like, so you have portfolio recovery and then you have LVNV funding come after you for the debt. LVNV funding is considered the third party. They do not actually own the debt. This is what I'm thinking is actually happening. I know that they might put it in their paperwork. They might phrase it a certain way, but these companies do not actually own the debt. That the portfolio company owns the debt, and they're utilizing the third-party debt collectors to come after people for the debt. Now, just to clarify, because I know I might have got you a little scrambled there. You will get a letter from a third-party debt collector like LVNV Funding, Jefferson, Capital, Calvary, stating that they have the debt. the way that they put it in this decision is they were actually breaking it down by the words that are used. So look for the words owned, if it says we own the debt, or if it says that they were assigned the debt. If they're assigned the debt, they're going to be under the Fair Debt Collection Practices Act. If they say that they own the debt, they're not going to be under the Fair Debt Collection Practices Act. But they can still come after you for the debt, but they don't have to follow that rule. So now let me tell you what you have to do. Let me tell you what you have to do. If Portfolio Recovery Associates comes after you for debt and they state on there that they own the debt, what you have to do is you have to tell them to give you a true accounting of the claimed amount that they say that you owe. Plain and simple. Yes, you would do this with a debt validation with a third-party debt collector, but because the portfolio company who buys the debt and considers themselves the owner of the debt, and who the Supreme Court considers is the owner and don't have to follow the Fair Debt Collection Practices Act, the way that you can beat them, the way that you can, in a way, your loophole is to make them prove the amount that they're saying that you owe. You want every charge. You want, if it's a credit card, you want all the charges. If it's a auto repossession, like in this case, you want everything that equals up to that amount, what the vehicle was sold for, everything, because the original creditor would have that information. So what I'm doing is I hired a company that's going to read the entire decision. This was back from 2017. And now it's, it's like came full circle. I can see the loophole that a lot of these portfolio companies like Sherman, Portfolio Recovery, Sherman 2, Sherman 3, these companies, what they do is they'll buy these debts. They know that they don't have to do a debt validation. They would have to prove the claim, but a lot of them are not directly coming after people. And even if they did come after you, when you utilize a debt validation, this could be the main reason why the portfolio companies like Portfolio Recovery, Sherman, when you try to do a debt validation of them, they're not required to do a debt validation according to this Supreme Court decision. So just to be clear, if they own the debt, they do not have to do the same type of debt validation according to the Fair Debt Collection Practices Act. You will mainly be focusing on how they came up with that amount. And I know that seems like a debt validation, and it is similar to a debt validation, but you're going to be changing the wording just a little bit, saying that they're the owner rather than them following the Fair Debt Collection Practices Act. You're just trying to get them to clarify how they're coming up with the claimed amount that they're saying that you owe. Now, this will also set you up to win if they end up trying to take you to court, because if you watch my videos, what I've always stated is that the number one thing that makes it hard for debt collectors or original creditors, or not original creditors, but debt collectors who buy debt, or these portfolio companies, if they decide to come and sue you, is that they do not always have all of the information to prove the exact amount that you owe. That they're going to have a few statements, but they don't have all of the charges. They don't know complete interest rate breakdown. If it's a credit card, the rewards, the payment history, credits, all of that stuff. This is stuff that is required. This is stuff that is overlooked when people start to think about balances, because the debt collection companies or the portfolio companies only want you to focus on the entire amount. They never want you to break it down and make them prove dollar for dollar exactly what you owe. So I'm having a company that's gonna read all 11 pages of this. I'm not gonna read all 11 pages out loud on a YouTube video. I think that I can get someone that would be a lot better at doing this. I'm gonna put the link under this video if you want to view it. So, so you can read this over and you can see how this is, number one, it is very It's like so many gray areas in this decision. Is unbelievable. And I think that you will agree with me on that. And it's just incredible that even if a debt collector buys a debt and they're considered the owner of the debt, that they do not necessarily have to follow the Fair Debt Collection Practices Act. I think that you will be, you'll kind of be scratching your head when you read through this. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, 3scores.com, to grab my TransUnion, your TransUnion, Equifax, Experian, credit reports, and all 3 scores. If you have debt collectors coming after you, third-party debt collectors, grab my 3-pack of letters: statute of limitations letter for debt that is past the legal statute of limitations to collect, debt validation letter, and cease and desist collection activities letter. That will take care of most debt collectors who are sending you letters early in the game trying to collect on the debt that they've purchased or that they've assumed or been assigned from another debt collector. Thank you for your time. Please subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.